Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about the case of the Queen in Partington. This is a case that's been in the news, and it's a bit of an unusual case because Mr. Partington was a police officer at the time and has now been convicted of assault with respect to the use of excessive force in the course of an arrest. The charges came about after video of the arrest was released to the public. The Crown Prosecution Service became aware of it. They reviewed all the video footage as well as the files, and they determined that it was appropriate to lay charges. So I've already mentioned that he was convicted, but let's have a look at the case to see how they get there, because the judge doesn't pull any punches in this one. We're also going to look at the video itself just so that we have some understanding of what exactly is going on here. All right, let's dive in. So Constable Michael Partington, the defendant, faces a charge of assault arising from the assistance he provided to Constable Curtis McCarger in detaining and arresting Elliot McLeod on the 27th of August 2019. Mr. McLeod prefers his birth name Hoole to the name McLeod, which appears on his birth certificate, and accordingly I refer to him by the former in these reasons. That's really common, it's just the judge being respectful. I call Partington the defendant instead of the accused because, pursuant to Section 786 sub 2 of the Criminal Code, the summary conviction limitation period has been extended up to and including June 17, 2020, the date on which the information was sworn. I assume that is done in fairness to the defendant, as a videotape of the incident, the crucial information which persuaded the Crown to proceed with the charge, only became known to the authorities many months after the alleged assault occurred. So you might be wondering, what does all this mean? Well, summary conviction offenses have a limitation period, and if the Crown waits too long, they can't proceed with a charge, unless the defendant agrees. You might think, why would the defendant ever agree? Well, most offenses in the criminal code are hybrid offenses, so the Crown has an option to either proceed summarily, which is less serious, or by indictment, which is more serious. And so if the defense is not willing to play ball and let them proceed summarily, they'll just go and lay the charge by indictment instead, which opens up the door to more serious punishments. So of course you agree to let them proceed summarily. That's all that's happening here. Now at this point, let's have a look at the video. I'm going to warn you that the video is a little disturbing. There's no gore, there's no blood, but there is some violence. So let's have a look. It is important so that we understand what's going on here.
Okay! Okay! Stop! Ah! Ah! Okay. Stop! Please stop! Stop! Please stop! Oh! Oh! Oh, my head!
Do not run from the police!
Stop, please!
You think I would catch you?
So key things to note here, Mr. Hoole is lying face down in the grass. He's not moving. He's not even saying anything at the point where Constable Partington comes up and then delivers a flying knee into his back. And then suddenly, of course, Mr. Hoole is real noisy and real wiggly, because that's what happens when you hit somebody. People don't like being hit. They try to avoid that. So when you see officers yelling, "Stop resisting," as they keep smacking somebody and that person keeps wriggling, well, of course, that's what happens when you hit people. Anyway, continuing on. There can be no doubt on the evidence that Constable Partington assaulted Mr. Hoole, but he relies on Section 25 sub 1 of the Criminal Code as a complete answer to the charge. That section, in its relevant parts, reads as follows. Everyone who is required or authorized by law to do anything in the administration or enforcement of the law, as a peace officer or public officer, is, if he acts on reasonable grounds, justified in doing what he is required or authorized to do and using as much force as is necessary for that purpose. So this is a special provision of the Criminal Code to protect police officers when they need to use force in the course of their duties. But that is if they're using as much force as is necessary, and if they're acting on reasonable grounds. So there's some serious limits on what force police can use, even though they have this special provision that provides them with special protection that the ordinary citizen doesn't have in terms of use of force. As Constable Partington gave evidence in his own defense at the trial, the decision of the Supreme Court of Canada in WD directs trial courts to adopt a three-step process in assessing his evidence. WD is a pivotal case on assessing this kind of conflicting evidence, and it is probably the most cited case in criminal law. So the court's going to explain how WD works, so I won't have to. First, if the court believes that evidence, the defendant is entitled to an acquittal. Even if the court cannot say it believes him, if his evidence still has enough persuasive value to raise a reasonable doubt, he is still entitled to an acquittal. Finally, even if the defendant's testimony does not raise a reasonable doubt, the court must still examine all of the evidence and be satisfied that the Crown has proved the case to a criminal standard. In this case, that includes negativing any Section 25 defense to that same standard. So because that defense is raised, and there's an air of plausibility to it, the Crown has to prove beyond a reasonable doubt that the accused is not entitled to rely on that special police protection. So you can see WD has an interesting sort of process. If the accused is providing a defense and that defense is believed by the court, you don't need to look at anything else. The court will not be able to get past that in order to find that the offense has been proven beyond a reasonable doubt. But they then next, even if they don't believe him, they have to say, well, could it raise a reasonable doubt? Is this something that, maybe you don't believe him, but you also can't really disprove it? So then an acquittal would have to follow. And even if you completely disbelieve the accused, you think, he's a liar or whatever else, you still have to say, did the Crown prove their case? Because sometimes that happens. Sometimes the court says, listen, the accused testified in his own defense, and I didn't believe a word that came out of his mouth. But the Crown didn't prove it, so an acquittal is going to follow. All right, carrying on. I can say immediately that Constable Partington has not reached either of the first two thresholds of the WD analysis. So the court doesn't believe him and doesn't find him plausible enough to maybe raise a reasonable doubt. That's kind of a big thing. Let's see what's going on here. His evidence in a number of particulars is simply unsupported by other completely independent evidence. For example, his suggestion that he felt the situation was so urgent that he went to the scene with both his emergency lights and his siren activated is contradicted, so far as the siren is concerned, by both the video, the radio dispatch recordings, and the evidence of Tyler Eaglespeaker, who heard no such siren. So the court is concluding that didn't happen. His stated belief that McCarger was in a foot race with Hoole is again contradicted both by the radio dispatches, where there is no suggestion of a foot race, but rather that the suspect had taken off on a bike, and by the fact that when the shift had begun earlier that morning, McCarger was patrolling in a police cruiser, not on foot. Ultimately, the defendant acknowledged that the radio dispatch log shows that the latter never used any words suggesting urgency and never specifically asked for assistance. A closer examination of that log reveals that it was actually the female dispatcher who, on her own initiative, sent other officers to the scene. So the court already is coming out pretty hard in saying that Constable Partington's evidence has some big problems with it. Even less convincing was his assertion that all struggles are, in his view, fights, when asked if he thought McCarger had been or was in a fight. Again, the logs confirmed the latter had told dispatch that he had got him and was simply waiting for other units to help him put handcuffs on the suspect. He didn't say anything to suggest he was in a fight. However, the defendant testified that to him, even a resistance to having handcuffs put on amounted to a fight, a proposition clearly at odds with reality. Ouch, that is some harsh language. Keeping in mind as well, courts tend to treat police officers with a little bit of soft gloves in my view, and I'm not the only person who's made this sort of notion. Courts tend not to find very strongly in terms of credibility against police officers because it can damage their career. But the court here is not playing around. They're coming out and saying there are some big problems with this. In the final analysis, it appears that the Constable Partington's sole ground for thinking there was an urgent need to respond was that McCarger was speaking very quickly and that his voice was higher than normal, which of course happens anytime adrenaline has happened, which can happen just from running after somebody or anything like that. During cross-examination, the constable ultimately agreed that he had launched himself at Hoole rather than having placed his knee between the suspect's shoulder blades as he initially said. So he said one thing and then ended up having to back away from that. That's really damaging when a witness has to do that. He conceded that, after he saw the video, his knee landed harder than he thought. He also said that he really didn't notice any screaming in response. Both of those assertions simply beggar belief given the dispassionate evidence of the video. So too does his assertion that he did not mention his use of force to Acting Sergeant Reynolds or file the required report because he felt that he had done nothing wrong. So let's break this down. First, the court is saying, I'm sorry, we do not believe you when you say that, the knee landed harder than you thought, because look at the video. You take a flying, this is some world wrestling style, flying knee things. So the whole harder than he thought, and you thought you placed the knee on, that doesn't seem to make any sense. He also says that he really didn't notice any screaming in response. Well, I certainly noticed screaming watching this video. Now, admittedly, I'm sitting in a chair. I've got a beverage in my hand. I'm playing armchair quarterback, but that screaming was real loud. It seems real hard to imagine that you wouldn't have noticed that. Now, the last part I think is even more damaging. He says that he doesn't mention this to his sergeant, and he doesn't file the required report because he felt he'd done nothing wrong. Well, it's a required report. It's not like you file this report only if you think you've done something wrong. You have to document any use of force that you use. So to me, not filing a report doesn't suggest, hey, this guy thought he didn't do anything wrong, so he didn't have to file the report. Because if you didn't do anything wrong, why would you be upset about documenting what you did? That to me sounds more like maybe somebody is hiding what they're doing. But yeah, let's continue on. So they're talking a little bit about the applicability of Section 25 now. So we're going to discuss that section. And one of the key cases is the Queen in Nasagaluk, which remains the leading authority on the interpretation of that section. It stands essentially for two propositions. The force allowed by the section is constrained by the principles of proportionality, necessity, and reasonableness, and police actions, given the dangerous and demanding work they are involved in, should not be judged against a standard of perfection. So police officers don't have to be perfect. They're allowed to make some mistakes and still fall under that Section 25 provisions. However, there's limits to that, and we'll see that as we go. So in the Queen and Bottrell, the court noted, in determining whether the amount of force used by the officer was necessary, the jury must have regard to the circumstances as they existed at the time the force was used. They should have been directed that the appellant could not be expected to measure the force used with exactitude. This is a common principle that comes up both in the Section 25 police use of force things, but also in terms of self-defense. The sort of standard phrasing is that you don't need to measure to a nicety the force used in the face of an upraised knife. If somebody comes at you with a knife, maybe you could use less force than you did, but you were in a tense situation. There's a guy lunging at you with a knife and, you hit him with a brick. Maybe you could have hit him with something softer. So that's what the court is talking about here. However, they'll go on to say, nevertheless, there are limits in applying the not with exactitude principle in assessing proportionality. Because, of course, even if you're saying we're not going to measure it to a fine point, there's got to be some level of force where it's clearly inappropriate, where it's just clearly improper. If we imagine an extreme circumstance here where Constable Partington had walked up and, again, this is purely hypothetical, but imagine he walks up, sees the guy on the ground, pulls his service pistol and puts two in his head. That's clearly extreme force. It's clearly not justified under the circumstances. So there is some point where that sort of gets broken from. They say, the fact that the threat assessment by the accused is based in part on trying to infer someone else's intentions also explains why a court must focus first on an accused's subjective perception of the degree of violence of the assault or threatened assault. Nevertheless, an accused's belief must also be reasonable on the basis of the situation he or she perceives. So you have to look at what the officer sees, what they say the analysis is. But that has to make sense in the circumstance. If you say this guy who's on the ground being held down is a deadly threat, and that's why you had to pull your handgun and shoot him, the court's going to say that's not reasonable. Even if that was actually what was going through your head at the time, it doesn't make any sense to a reasonable observer. With respect to the proportionality requirement, the responsive force must have been no more than necessary in the circumstances. I've included that this should be assessed using an objective test only, so not from the view of the officer as to what was necessary, but from the view of the reasonable observer. By this, I mean that the trial judge is to consider whether, from the perspective of a reasonable person in the circumstances of the accused, and the accused here means the officer, not the guy on the ground. When we have this sort of situation, Constable Partington is the accused in this scenario. There is an air of reality to an accused claim that the force used was objectively no more than necessary, given the nature and quality of both the threat and the responsive force. That reasonable person is to be invested with the characteristics of the accused in terms of size, strength, gender, age, and other immutable characteristics. If the responsive force used exceeds that which was objectively necessary, then the protection of Section 34, which is self-defense provisions, is lost. And the court is saying, listen, this is talking about self-defense provisions, but it also applies to these protections for police. So in terms of what force is reasonable, we can, it matters who you are. Because let's imagine, for instance, that somebody comes up to you and, they're attacking you, but they're attacking you with their fists. If this person happens to be, 8 feet tall and as wide as a bus, they're all muscle, it might be more reasonable for you to use more force in repelling that than if they happen to, be, 5 foot tall and skin and bones and barely able to stand up. If you're smaller or weaker or perhaps injured, then you might need to rely on more force than might otherwise be necessary. So all of these things are to be considered. However, allowing an accused considerable latitude in measuring the degree of responsive force employed was never intended to confer on an accused a license to resort to whatever responsive measures he or she thought justified, no matter how unreasonable or disproportionate those measures might be. To permit an accused to do so would collapse what Parliament intended to be an objective requirement into a subjective one. Requiring defensive force under Section 34 sub 1 to meet a proportionality requirement discourages unreasonable resort to violent self-help, a legitimate goal of any criminal justice system. So what the court here is saying is, listen, reasonable force to defend yourself is allowed, but unreasonable force is not. One of the most common circumstances where you see people step outside a self-defense situation is, let's say somebody attacks you and you win the fight. And then that person is laying on the ground, you've won the fight, they're no longer a threat, but you're still angry and you still got adrenaline going and you decide to give them a few kicks to the head. And sometimes those kicks to the head can cause serious injury. That's a point where you've probably stepped outside of reasonable force because now you're applying force to somebody who's not a threat to you anymore. I've skipped ahead a little bit here and skipped over some of the assessment of Mr. Hoole's credibility, so that's sort of the context here as we continue. What is more important to me in assessing his credibility, and that's again Mr. Hoole here, is that the most crucial parts of his testimony are supported by other evidence. His suggestion that he was punched in the back of the head 4 to 8 times and that they were pretty good shots is confirmed by McCarger himself, who said he hit him 2 to 3 times, maybe 4, and that he was hitting as hard as he could. So too is his evidence that shortly after he told the constable that he was giving up and then he put his hands to his side, McCarger quoted Hoole as saying, "Okay, I'm done," and putting his hands at his side. Once again, his allegation that he was punched after he was handcuffed, even if it didn't happen exactly when it remembered it did, is also supported by the video, which shows McCarger hitting him on the back of the head as he was being taken to the defendant's cruiser after he was handcuffed. This portion of the video I haven't been able to find, so unfortunately I can't share it with you. His story that he was yelling both before and after the kneeing incident and crying out for help is confirmed by both Tyler Eaglespeaker and Jason Grimm. In the end result, I find those parts of his testimony both believable and substantially accurate. Mr. Daniluk also cautions me against placing too much reliance on the video because videos can be misleading. Mr. Daniluk here is the defense lawyer, and I know Mr. Daniluk, he's an excellent defense lawyer. This is a tough place to be in for a defense lawyer because you've got video evidence that is a problem. Now, video evidence is often inconclusive. It can often be difficult to interpret. So that's sort of the argument that's being made here. It says, in support of this, he cites two decisions from other judges of the court, Queen and Wilcox and the Queen and Baumeister. Having reviewed those decisions, they are readily distinguishable from the video here. Both videos are essentially security cameras with no sound. Security camera footage is often really bad. There's a lot of really cheap security cameras out there that just sort of show vague blobs moving around. But that said, a lot of security camera footage is getting much better nowadays. In one case, the defendant's back is to the camera through most of the recording. In the other, the camera is in a fixed position and vision of the defendant is partially obscured by the complainant's body at crucial times, and his back is towards the camera at others. There's nothing like that here. This video was not recorded on a mounted camera, but on a cell phone with audio and a live person both operating it and observing what it was recording with his own eyes. Mr. Grimm, his father, was also there and observing events as well. I found the quality of the recording to be very good, and backed by the testimony of the two witnesses above referred to, it provided valuable evidence. So the court is saying, I get what you're saying. Sometimes video's not so great. This video, on the other hand, is real good, and so that's a problem. There remains to consider the evidence of three other witnesses. Not to be outdone, Ms. McPhail for the Crown invited me to doubt the evidence of Constable McCargar, even though he was called by the prosecution. So he's not a defense witness. The Crown actually called this police officer in order to help with the conviction, but that officer was providing support for the accused. If you're wondering what kind of accused the officer will testify in support of, I've never seen this outside of police officers as accused. So in this, she has had more success than defense counsel did. I found the bulk of McCargar's evidence extremely self-serving and principally aimed at justifying his own conduct and maximizing that of Mr. Hoole. So he doesn't find Mr. McCargar to be all that credible. Instead of just answering the questions put to him, he often amplified them by telling me what was going on in his own mind, the so-called what-ifs referred to by Crown Counsel in argument. For example, in saying he didn't believe that Hoole had given up when he said, "Okay, I'm done," and put his hands by his side, he said that the man was still wriggling and in McCargar's mind might still have decided to resist. So we're going to use force on the basis of what he might do? I mean, there's all sorts of things that people might do. When I walk by somebody on the street, they might punch me in the face, but I'm not entitled to, deck them first because they might decide to do something crazy. So none of that is confirmed by Tyler Eaglespeaker. In attempting to emphasize his own danger, he told me a number of community members came out as he was attempting to restrain Mr. Hoole, and that one of them, a woman, came up to him and asked if he needed any help. A complete fabrication on the evidence presented. That is a hell of a line in a decision referring to a police officer. Saying that his evidence is a complete fabrication, the judge is basically saying this is a lie. That's a big deal. Expect that for the rest of Mr. McCargar's career, people are going to refer to this. So neither the video, the defendant, or the two who were watching from their house make any mention of anyone else being present, much less a small group of community members. When asked, the constable conveniently conceded that he didn't take their names. Really convenient. You got a whole bunch of witnesses and you just don't get anybody's names? Yeah, why bother getting witnesses? He describes what Constable Partington did as a knee stun, but can't say how much force was used even though he was kneeling there only a foot or two away in the video. His excuse for that is that it was done quickly. In the result, I find Constable McCargar's evidence unreliable and largely intended to minimize both his role and that of the defendant. So one thing I'll point out here is they say the defendant, the accused in this circumstance, doesn't testify about these community members. And you might be saying, well, wouldn't they just kind of harmonize their evidence? Well, an important thing in trials is that you actually exclude other witnesses. So when one witness is testifying, the other witnesses, except the accused, who's got a right to be in there, get removed from the room. So typically the accused is going, or the defendant in this case, is going to testify first. And after they've provided all of their evidence, then other defense witnesses would come forward. This one's a little different because this would have been a Crown witness, so that would have been called on the Crown's case. But the defendant doesn't back up the other witness there. Skipping ahead a little bit more, they say, and then there's the video itself. I viewed it a number of times. The picture is very clear and the sound remarkably good. I have no doubt that when Constable Partington arrived, Mr. Hoole was face down on the ground with his hands behind his back, held by Constable McCargar, who also had one knee on Hoole's back. At that time, the latter was neither moving nor making any sound. It shows the defendant take 1 or 2 steps and then aggressively drive his knee into Hoole's back, whereupon he screamed and began yelling for help and providing, at that point, some resistance to the officers as they got him to his feet and put him in the back of the defendant's police cruiser. I think the phrase launched himself with his full weight at Mr. Hoole's back, used by Crown Counsel in her cross-examination of the defendant, aptly and accurately describes what I saw in the video. Against that background, does Section 25 legitimize Constable Partington's assault on Mr. Hoole? It does not. Given what he knew and then saw when he arrived, there was no necessity for an assault at all. The guy's on the ground. He's not moving. He's not fighting. You didn't need to knee him. And if there's no necessity to knee him, that's going to be the end of that assessment. As he admitted in cross-examination, he cannot have known of any injury to Constable McCargar's hand, and this is the first time this actually gets mentioned in the decision. Apparently, Constable McCargar hurt his hand, if there was one. I say that if there was one because, as the video shows, it was Constable McCargar who reached behind his back with that hand after the knee stun to get his handcuffs and put them on Mr. Hoole, not the defendant, who could have used his just as easily. I conclude that whatever injury there was to his hand, it was not as serious as Constable McCargar would have had me believe. Ouch. That's again a really bad, if you're a police officer, this is a really bad thing to have a judge say about you. As indicated in the cases, the time which must be considered in evaluating the legitimacy of the use of force is the time at which the force is used. As the video clearly shows, when the defendant arrived on the scene, he saw the suspect face down on the ground, neither moving nor speaking, with Constable McCargar kneeling beside him with one knee on his back and holding his hands together. I know the defendant said Mr. Hoole was writhing on the ground when he arrived. I reject that evidence, not only because it appears that this is the first time Constable Partington has mentioned it throughout all of the investigations involving this incident, including the initial one against Mr. Hoole, but because it is refuted by both the video itself and the testimony of Tyler Eaglespeaker and Jason Grimm. Given what he knew and saw, I can only conclude that the defendant's knee stun not only was unnecessary, but in the circumstances, a gratuitous assault on an unresisting suspect. Again, ouch. Given that conclusion, Section 25(1) cannot assist Constable Partington, and I find him guilty as charged. All right, so that is one heck of a decision. That is pretty brutal if you're that police officer, because it's really difficult to come back from that. The other thing I'll mention is that little bit of video that we saw, you can actually see the officer saying, something along the lines of, don't run, and what did you think would happen? I'm not quoting it directly here, but, they talk about him running. And so a lot of people had the thought of, was this use of force intended as a punishment for running away? Certainly what the court found is that it was a gratuitous assault. So not one that's justified by the circumstances, but for some other reason. And that other reason is not going to be a good one. There is no good reason for why you'd throw your knee at this guy if it's not necessary. So that's a really tough decision. The next question, of course, is what's going to happen on sentence? And we don't have a sentence yet. I expect that's going to take a while. They're going to get together all of the, sort of documentation. Of course, police officers tend to be in a fairly favorable position on sentencing because they can say, listen, I've been serving the public for however long. And the one thing that never really comes up that I really think ought to come up more often is, we expect high standards of police officers. We expect them not to do things like this. And, when we say we hold police to a higher standard, surely that should mean that when they break the public's trust by engaging in these kinds of actions, that the more serious punishments should follow. It'll be interesting to see what ultimately happens. It'll be interesting just to follow up on that. There's also the possibility of an appeal. However, an appeal is going to be somewhat difficult here because an appellate court is going to they offer deference to the trial court on issues of credibility and witness assessment because the trial court gets to see what actually, how the witnesses testified. The appeals court doesn't. All they get is just transcripts. So the appeals court is going to say, listen, we trust the judge who is in the court and their assessments of it. It's very difficult to overcome those kinds of credibility assessments. So it'll be really, it'll be a bit of an uphill battle. I haven't gone through this in enough detail to say for sure whether there is or is not an appealable issue. Really, that would take transcripts to do it properly. I didn't spot anything immediately going through the decision. And frankly, with those credibility findings, I think it would be difficult. The video itself is really a damaging bit of evidence. I also think that this case and cases like it have the potential to really affect some change, because as a society, we're becoming more and more concerned by the potential for police abuses of force. We're becoming more aware of this, and we're starting to see more prosecutions brought. This is an opportunity for the court to clearly communicate that we do hold police officers to a higher standard and not to a lesser standard, a more forgiving standard. So it'll be really interesting to see what happens on sentencing. The other thing is I'm hopeful that in policing culture, there'll be an understanding or a realization that police officers who go too far, who use excessive force, who maybe shade the truth, these kinds of things are not just a danger to themselves and to the members of the public who they interact with, but also to their fellow officers. That if you are working with somebody, that these people have the potential to drag you down as well. And that, I think, is potentially something that could be a major force for pushing bad apples out of the force. Ultimately, we'll see. It's too early to tell, but I'm hopeful. I am hopeful that we can solve some of these societal problems and improve things going forward, especially because there are so many good officers out there, so many people who are struggling and striving and doing their best. And what I've heard from these officers is essentially the worst part of the job is sometimes their fellow officers. Not always, but sometimes. Anyway, thank you for watching. I hope this has armed you with knowledge. Please like this video. Please share it with your friends. Please subscribe to see more content. I also have a link to my Patreon below. I'm also going to link to the decision so that you can read it in full if you want. I want to thank my Patreon supporters at the $50 level: Jonathan Wheeler, Jason Elliott, Canada's National Firearms Association, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Demour. And at the $20 level, Raymond McKinnon, Matt Ward, Mark Whittington, Dale Nesbitt, Cameron Johnson, and Andrew Elsich. I also want to thank my $10 supporters who will be in the crawl immediately following, as well as all of my supporters. Thank you once again for watching. I hope this has armed you with knowledge. See you next time.